tell us a little bit about yourself and your background, and let us know how long you've been on the bench. Just tell us a little bit about yourself.
How far back in my background do you want me to go?
You've got 20 minutes to talk, so you think about how much time you want to use, okay?
Okay. All right. So I was born and raised in Cleveland. I graduated from Glenville High School. I have lived in both the city Cleveland proper as well as the outer ring suburbs. I currently reside in Solon. I've been in Solon for about 18 years now, 18, 19 years. I did all my schooling in Cleveland. I graduated from Ursuline College. I attended Ursuline while I was working at Bank of America. At that time, it was MBNA. And I attended school in the evenings while working full-time during the day and raising my family. So it took me quite a while to get my undergraduate degree. My degree is in business administration, and then I have a minor in marketing. And when I decided to go to law school, I was not the traditional student. I was in my late 30s, and I decided to continue at Bank of America. At that time, they had been bought by MBNA, so I attended school, law school in the evenings while raising children, and finished in 3 years and took the bar exam and started a small family law practice. I have a total of 6 children, 2 stepsons, 4 biological children. And they range in age from recently turned 5-year-old all the way up to 28 years old. I do have to give a little disclaimer that you may hear the 5-year-old. I've explained to her that I am in a meeting. She understands the concept, but she doesn't appreciate it, so she may come in. So if you all will just bear with me if that happens.
Okay. How have you helped right the wrongs of a flawed criminal justice system that is preyed upon poor people and minorities since you've been on the bench?
So I will tell you, there are some issues that I have seen, and one of the issues is related to the way that a person is charged at the onset. I feel like one of the common practices is to charge a whole lot of stuff with the idea that as the case proceeds and you get to, the plea date or the trial date, then certain charges will be dismissed. And one of my concerns about that is that what ends up happening is when a bail is initially set, the judge doesn't have any evidence. Like, I don't review any evidence in the case because there's a possibility that the defendant may opt for a bench trial. And so I can't have already reviewed that evidence and made any sort of, because you could make sort of judgments about what you're going to see before you actually get to the trial. So you're not to do that. So the judge doesn't have any information about the facts underlying the indictment. So what could happen is someone could be charged with a lot of stuff, and maybe there's not evidence sufficient to support each charge of the indictment. So one of the things that I do is I have bond hearings, and I recently modified the practice that will be happening in my court, which is rather than, I normally would wait about 10 days, 7 to 10 days before that bond hearing would happen, because I have to give the prosecutor or the state time to respond to the motion for bond reduction. Well, that time frame has been shortened significantly. So that's one thing. And at that bond hearing, one of the things that I ask of the state is to outline the facts supporting, because I have to consider the weight of the evidence against the defendant. And so it's really important to make sure that, if there isn't evidence to support that charge, I can't tell the state to dismiss it, but what I can do is not consider it for purposes of bail. So it's one of the things that I have to consider. So that is one thing. The other thing that I've done is when it comes to evidentiary issues, I always give a hearing, and I get case law, and that's a practice that I don't think was really happening before, because a lot of the attorneys seemed a little bit surprised by the way that I handle that part. But I have hearings, and I consider very carefully all of the case law. And I actually think both the state and the defense counsel in criminal matters appreciate it. As far as civil matters, because I have done some things, you know, in the civil matters that I have in my courtroom, and one of the things I do there is I'm always very actively involved, especially at the final pretrial, on ensuring that I am there and I am available, so that I can't get involved in plea negotiations, but I'm there, and settlement negotiations. I'm there and I'm available, so that the parties are. Sometimes I find that they actually need that, and it does sort of move along settlement discussions in civil matters. I also make very sure that I take whatever time is necessary during plea hearings in particular, that the defendant has to know that they are voluntarily, intelligently waiving rights, and I make sure, I ask if the level of understanding, I get a confirmation from the defendant at almost every single question that I ask. And that takes a lot more time, but I think it's worth it, because we're talking about someone's freedom in a lot of these cases.
That's correct. What new or different perspective have you brought to the court since you've been appointed?
I think I can probably best answer that question with an example. And the case is done now, so I can talk about it. There was a case where a woman was charged. She's an African-American woman. She was charged with assault. She was charged with, it was an F3, so she was facing some prison time. And her case probably took about 5 months from the date, of the indictment until the trial date. So we come in, it's trial date, and the state asked for a continuance. The reason for the continuance was because their only witness wasn't there. I asked questions, did the witness know about today? We go through that whole process. And this woman, she had not been able to work for that 5-month period of time while her case was pending. And my concern about it, she said it, was she was the sole income provider for her household, and she was facing possibly losing her housing because she couldn't work with these, charges outstanding. She worked for a home health care type agency, and she would transport disabled individuals to different appointments. And the accusation was that she had hit one of her charges. The witness was a coworker, and when I said no to the continuance, the response I got was, if you don't grant this continuance, we're just going to re-indict it, and the plea offer will be off the table. So my background, I know what that feels like to not have income coming in, because when I grew up, my mom drove a bus for RTA. And before she drove for RTA, she was a school bus driver. During the time when she was a school bus driver, in the summers, she didn't have income coming in.
Yeah.
So often, those 3 months, they were tough. Like, I think cabbage soup is a thing. Like, we had that, during those summers. So I know what that feels like. And sometimes, if you don't have that sort of experience, you don't understand the context of what it means to not be able to work and feed your family for 4 or 5 months. Mm. So a continuance was out of the question. And I felt, the defendant was being put in a position where she was going to plead to something that she wanted her trial. She, insisted that she did not do this. And it turned out at the end of the day, this defendant, the witness changed their story multiple times. and the witness didn't show up on the trial date. And I did not like what I was hearing, and I didn't think that it was fair. And so I ended up, I believe she pled to a minor misdemeanor, which that's the only time I've ever taken a plea for a minor misdemeanor in my court, in felony court. And I ended up sealing her record because those charges hang over her head when, after questioning, the state about the weight of the evidence, this is after she had already pled at sentencing, I felt the right thing to do was to make this woman whole. Her life had been turned upside down for 4 to 5 months. And that's what I did. My perspective and my background allowed me to be able to understand what that meant and make the right decision.
You mentioned something about civil and criminal litigation. What are your experiences with criminal litigation as well as civil litigation?
So my background was in civil litigation. I had no criminal litigation before I took the bench. I have been on the bench since January of 2019. So when I hit the ground in January of 2019, I did have to hit the ground running. I had taken some classes that first month on evidentiary issues. So I was getting myself up to speed very quickly. And I'm glad I did that, because my very first trial was one that a lot of judges, when I called and asked them questions about it, they had never had this issue, but I had several, the witnesses, the defendants, there were co-defendants, they all spoke Spanish. So I had to have a certified interpreters. It slowed the process down. It was a unique experience. And I got myself up to speed in order to be able to handle. So I've had several criminal trials. So at this point, I would say it was trial by fire for the criminal matters, but I had already had, my background was in civil matters. So I think I'm well-rounded and in both civil and criminal matters.
Okay. Since you've been on the bench, what do you perceive as the greatest obstacle to justice in the division on the common pleas bench where you're a judge?
Honestly, I feel like diversity on the bench is a huge problem. There are 4 African-American judges out of 34 judges on the general division bench. I am included in that number, and I was not elected, I was appointed. So, there were 3 judges. Judge Turner and I started at the same time. So for a number of years, there were 2 Black judges out of 34, and those were both female. So right now we have no Black men on the bench. And considering the population and the diversity of the population in our county, I think that's problematic. I mean, I've seen the looks on defendants' faces. It makes a difference. And I'm not talking, I don't, say, okay, well, I'm Black, you're Black, you get a break. No, I follow the law, but I follow the law and I treat people with dignity. I treat them in a respectful way. And I think that that's something that translates, I do think that diversity affects the way that people perceive fairness in our courts.
Do you believe that there's an underrepresentation of people of color in the justice system? Absolutely.
I think you may see, if you look at, and I'm not talking just the courts, I mean, if you look at the public defender's office, out of all the public defenders, there might be 7 African American. There are only maybe 2 Hispanic. In the prosecutor's office, I can count the number of African Americans in the general division and the major trial division. There aren't that many. And I think when you look at the population of our county, that representation, it's not balanced in any meaningful way. And I also, I mean, I don't see very many Latina or Latino prosecutors, public defenders. There are a few, but certainly it's not representative of the people that we see every day.
What is your opinion on pro se litigants? Do you think you can fairly adjudicate, or have you fairly adjudicated individuals who have cases with pro se litigants?
Yeah, I mean, I've had pro se litigants in my courtroom. Hiring an attorney is an expensive endeavor, and these cases can go on for very long periods of time. I was in private practice, so I know what it costs to handle a case. And a lot of people who have meritorious, complaints can't afford counsel. And so I have to hold them to the same standards that I would an attorney. But I think one of the complaints I've heard from pro se litigants is they feel demeaned or dismissed. And I don't think that's right. I think it takes, for someone to take on the justice system in any respect, I think that deserves to be treated in a dignified way.
Would you hold police officers to the same standards of law as citizens in Cuyahoga County?
Tell me what you mean by that. I mean,
would you be willing to look at an officer, and because they are a police officer, you just take their word because they're a police officer? Or would you look at them and hold them to the same standard as you would a common citizen in Cuyahoga County?
Well, I know that you guys have done some research, and so if you've Googled me, I did have a media case. Like I said, I've had, even though it's been a short period of time, somehow I ended up getting a varied number of strange cases. And I did have a case with a law enforcement officer who did a bad thing that didn't make a lot of sense to a lot of people. And it didn't make sense to me, and he didn't really have anything to add to anyone's understanding of what he did. And it was the Euclid case. He urinated on a young child who was at a bus stop. And if it's available on Facebook, or I think it was Facebook Live. I know media were in the courtroom and there is video of it. And if anyone wants to take a look at that, you can see how I treat a police officer who has crossed the line. First of all, because they are held to a higher standard, I'm probably a little harder on a police officer because they are held to a higher standard in our community, just like I am. So doing something bad, where people are harmed, I think should be met a little differently than your average everyday person, because there are benefits to being held to a higher standard. And I think my criticism, which I did make a criticism on the record in that case, and my criticism was that young 12-year-old little girl went to school after this traumatic event happened to her, and that no one at that police department took her story when her mother took her to the police department. Mm-hmm. And I believe I said that on the record, and to this day, I still feel that was a dismissive way of treating a child who had had a traumatic event happen to them. And I pray that that little girl is doing well.
Bishop, that is time.
Okay, well, thank you, Judge Jones, for being a part of our ratings and endorsement process. We thank you for taking time out of your schedule to be a part of it and answer these questions. You've given us more insight to your background, and we thank you for being a part of this process.
No problem. Thank you for having me.